Okay, abusia yebemo bibia kwaba shronko so ariaba POG Media. So abusia eye former finance minister Ken Ofori-Atta yeyeti a yetwen se eye OSP kisi daben ebetimi abon homoden ede na bawuram ewo Ghana ha ne boni a odi Ghana no waba ababetu asoka no Ken Ofori-Atta isan se oye criminal tactician man nti ende dua me no kasai Ken Ofori-Atta etimi abawuram ewo chese US Immigration and Citizenship Services abusia o change ne nationality a chese Ken Ofori-Atta pese si oye US citizen na chese Ghana no o nyandampo na waba na busia OSP kisi jaben is better say ye be remove no with immediate effect. And yes, I Ken Ofori-Atta and Nadia Yen Sabekano. And now I say Ken Ofori-Atta and Neneba ye everything within their power say Omube change ye Ken Ofori-Atta and nationality no ababe ye US citizen. I mean waste time no lawyer Martin Kpebu nebeliki da info we at the my mommy uncle in tie some of the two dan answer bekono jumedi when I like ya make sure so be like subscribe to the channel now so share jumedi no ma for nsa into me and Kpebu.
Don't call them others for corruption related offenses. In all, there are 78 counts of corruption and corruption related offenses. The other accused are Ernest Daku Akore, 67 years of age, chef de cabinet to Minister of Finance, or the former Minister of Finance, Emmanuel Kofi, 66, former Commissioner General of the Ghana Revenue Authority, Reverend Amishadai Owusu-Amoah, 64 years, former Commissioner General of the GRA. The rest are Isaac Krentil, 63 years, former Commissioner of the Customs Division of Ghana Revenue Authority. Kojo Damoah, 65, he is a member of Parliament. Kpebu. Yeah. And then also he's a former Commissioner of the Customs Division of the GRA. Ivan Seduse, 62 years old, beneficial owner, CEO, and controlling mind of the accused company and the beneficiary company itself, Strategic Mobilization Limited, SML, formerly Strategic Mobilization Enhancement Limited. Now, if you recall, on October 31, President John Mahama ordered the immediate termination of all contracts with the SML following the completion of an investigation by the Office of the Special Prosecutor, and indicated that the move forms part of a commitment to accountability and transparency in the management of public resources. Here's what we do know, and let's clear this. After this became public, we got notice of Ken Ofori-Atta being taken off, or we were not seeing his picture on the Interpol website on the red notice. The special prosecutor has sought to explain why Ken Ofori-Atta's picture and name is not on the Interpol red notice, or has been taken off or redacted, for the lack of better expression, from the Interpol's red notice database. He says there's some review that's going on. But is that standard practice, lawyer, from what you do know, that if there's a review going on of a sort, because there's some new information available to Interpol, they will take the person's name and details off and the wanted notice off while the review goes on, and afterwards what? Put him back?
That's if the yes, show that he should be put back. So the context is that currently there is let's call it legal proceedings at Interpol. Mm-hmm. So they have a unit responsible for this. So it's practically like a court on its own. So OSP, or let's say Ofori-Atta against OSP. Mm-hmm. So you file, the Ofori-Atta is complaining that there's no basis to have him on the Interpol red alert, blah, blah, blah. Then OSP says, no, there is. They say, okay, each of you file your case. They've done, then there are responses. So if you read the procedure, it's practical, there's going to be a decision. So judicial, well, okay, it's administrative, since it's not a court. Some administrative proceedings in there. So they'll go through each part to argue their case, present what evidence they have. Then at the end of the day, the committee would come to a decision on it. So if they come to a decision that, yes, Ofori-Atta's name should be fully restored, it will be done. If they come to a decision that there is no basis, then his name will be taken up. So really, and when I say his name will be taken off, let me correct this because OSP is very particular about it. It's not as if his name is totally off the system. As what it means that right now is restricted. You and I can't see it as Ofori-Atta, but the value is the same. Basic thing is that he's no longer a person that if any Interpol member saw today, they can arrest. That's the real point because once he remained on the list, and when we say Interpol, so Interpol is what? Police organizations around the world. So the countries that have joined, over 100, right? So that means that once he's on the red notice alert, it means that if he was found in Togo, they could arrest him. If he was found in the US, they could arrest him. So now with what has happened with this decision to restrict him, so it means that if they found him today, they will not arrest him. That's the most important thing.
I see.
Yes.
So if he is seen today,
yes,
to the extent that
yes. He's been removed, restricted. We are using effective communication. The key thing is, what is the effect of what has been done? The main effect is that he will not be arrested. So
if
whether
he's seen today?
Yes. So whether you call it removal or what do you call it, restriction, the key thing is that would he be arrested today if he's found? No. And now let's situate this. So it's not really about the Interpol red notice. So what it does is to like blacklisting. Okay, so it's something, there's some effect in a blacklisting. But if we look at what Ghanaians have been looking for, which is that he must come back to Ghana, that one is a long shot. Long shot because even if he's arrested today, he will not be automatically brought to Ghana today or tomorrow. No. You see the extradition that the Attorney General is working on, that is what has to be granted. You know, they will do it, send it to the U.S. government. Then the U.S. government will go through it, the Home Department, blah, blah, they look at it. Then they will go to court. So eventually there will be court proceedings in the U.S. because Ofori-Atta will contest his return to Ghana, right? And so it's not today or tomorrow. And you see why every day I'm pained and I keep saying that. So the man who allowed Ofori-Atta to escape, that's Kisie Jabe, has to leave the office immediately because he's fueling the suspicion that they colluded. Let me tell you something. You know how this world works. Because people want justice in this case, I've been given credible information that all this while in January, when we started saying that, look, if Ofori-Atta is not coming, then let's take steps to do trial in absentia so that we can confiscate his properties, etc. And it wasn't done, they delayed. It turns out that in the interim, Ofori-Atta is trying to get permanent residence in the U.S.
You got this information from where?
Oh, you know, this work we do, if I had to disclose all my sources would dry up.
You say it's credible.
Yes, credible. Yeah, but I have to keep citizen journalism. I have the right to keep them. So right now, the key thing is that, and that's why it's even irking me more. So as OSP was doing Kukwasa, Ofori-Atta through one of his sons has applied for him to get permanent residence in the U.S.
I see. And
so
this,
that
and this
complicates his return.
I see. This you are able to prove.
Sorry?
You're able to prove because this is from a credible source.
Yes.
So you have enough information to prove that indeed he has applied to get permanent.
Oh, no, they will release it. But I look at where the source is coming from. I believed it. And of course, if push comes to shove, we'll go into the U.S. system. That at least is there. Okay, we'll do a request, RTI request to the Homeland Security and the Home Department in the U.S. So the key thing is that as we're here from January, we started asking for trial in absentia. OSP came and were giving us ridiculous answers that no, you cannot do trial in absentia. 11 months only to do a U-turn. So then it fuels the suspicion. The analysts are like, oh, so were they denying trial in absentia so that it gives Ofori-Atta enough opportunity to get permanent residence?
Because they're going to court on Monday.
Yes.
The fugitives, as has been described, they are not in the country, obviously. So the trial is going to go on.
Yes.
What's going to happen on Monday is they're going to hear them.
Yes, but that
will be in the absence of Ofori-Atta.
Preliminary
Does that amount
matters.
to a trial in absentia?
Yes, the trial is, let's say this, before the trial in absentia will be done, Article 19, Clause 3 requires that the OSP will prove to the court that Ofori-Atta has been notified, the very thing we have been talking about. As to how they do the notification, Monday will come, then we'll see. If they've done it, fine. But if they've not, then it means that for Ofori-Atta and Esakori, his chef de cabinet, or is it chief de cabinet, his PA, let's use the simple term, his PA, the trial for them will not go on if there is no proof, cogent proof that they've been notified. Because let's read 19 clause 3. It says that he has to be notified. So if the accused is notified of the trial and he doesn't come, then that's when the court will go on. But please, that technical term, well, in this case, I would say technical because it's not cheap. Notification, that's what OSP has to prove to the court. And this is what lawyer Tadiosori had been saying from day one. You know, Tadiosori was one of the first to say, let's do trial in absentia. In January, when this matter came, if you check the records, I think for me, in reading commentary on this matter, lawyer Tadiosori was the first to ask for trial in absentia. Then later, all of us joined. Me, initially, you know, we thought, oh, he would come. And, you know, but it turned out that at least some of us converted far earlier and joined Tadiosori in asking for trial in absentia. And OSP kept stonewalling, whilst Ofori-Atta is taking steps to get better residence in the US so that his coming here will be more complex. And don't forget that he has huge investments in the US. Huge investment. And the American government will not lightly throw him under the bus. So you have to be very careful. This is a political decision. Look, at a point, after Kissi Ejabin is left, later in our series to get justice, we may have to organize a demonstration to go to the US Embassy and present a petition. That's what we have to do.
Okay, abusia eticha sensem na mobi eneko ekokoti ne ma show jumedi wonya like ya be like subscribe to the channel na so share jumedi no ma foforo sensa into me enkebi afi busia momianko ne nkonkoti efa etosumienu no eye chairman wuntumi no lawyer efen Andy Apia Kubi enso edensem ba kumienu eso so efa eye Ken Ofori-Atta ene OSP sensem momianko ne nkonkoti.
We have to mobilize Ghanaians after Kissi Ejabin is left, because that's the first point. We can't trust Kissi Ejabin to do this work because he saw Ofori-Atta leave. He saw the letter. I'm happy Professor Ajampo is here. Please, Mr. Okansi, when he gets to his side, let him explain the political theory of the state. How, when I keep saying, when I quote the constitutional provisions and I show that under the constitution, Kissi Ejabin had a mandatory duty to inform Ghanaians once he saw Ofori-Atta was leaving, and he alleges that the other.
So you expect that you address a press conference?
Exactly. So I want Professor Ajampo from the governance experts to come. And also, no, there's also governance. Let all the governance experts weigh in. Then we'll see that it's a serious constitutional matter.
You see,
serious
in this instance, I'll come to you.
Okay.
I'm sorry. But his lawyers are saying that he has not been formally served.
So that's why we said on Monday, we'll hear that. So let me just read it. That's why I said, cogent evidence, how he's been served. 19.3, just for those who want to hear the constitutional words, then we'll move on. It says, the trial of a person charged with a criminal offense shall take place in his presence unless A, he refuses to appear before the court for the trial to be conducted in his presence after he has been duly notified of the trial. So after he has been duly notified. So Monday we'll see, maybe if OSP did it and has not told us yet, well, Monday we'll see. You see, but the key point we're making is that the extradition itself, look, it's not a joke. It's a whole process. That's how come I said after we get Kissi Ejabin out, we have to mobilize Ghanaians. Once the US government understands that citizens understand what's going on, that extradition is political, maybe it will help them to bring Ofori-Atta. But if we leave it to TV analysis, you know, they also gauge public opinion. If a few experts come and sit here and say extradition, and lots of our citizens are not bothered, it won't happen today. But when we mass up a lawful demonstration quietly to the US Embassy and present a petition that we want the American government to bring down Ofori-Atta, it would help.
So that extradition process is what I reserve that for lawyer Christian Mamhesi because he's written quite extensively on it. So I'll come to you on it. But Honorable Apia Kubi.
Right. In fact, I'm a little worried about the whole process because I've heard of lawyers of Mr. Ofori-Atta also writing to OSP and responses coming and publications thereof. And I asked the question, upon what information is lawyers writing to the OSP. Is it the case that OSP has served Ofori-Atta a process for which reason they are responding and even suggesting dates of his arrival and his interrogation? Is that the case? It's another big question we have to answer. If there was no such correspondence or information, lawyers will ordinarily not act without instructions. So the presumption is that Mr. Ofori-Atta has knowledge of any such invitation and has instructed his lawyers to respond. Otherwise, the lawyers would not, out of the blue, just come out and respond. And your relationship with your client is not in perpetuity for you to say that once you hear that my client, you have mentioned my name, I write. No. In all situations, you must take instructions from your client, because when he is even your client on retainership basis, something new comes, you need to inform him and then take instructions in relation to that which would have come to the fore. So I'm worried. I don't understand why lawyers will respond if he has not been informed of anything. And the reduction from public view doesn't connote withdrawal of his name from the shadow of Interpol.
So
it says that it is only the public who cannot see.
But he's still
It is not by way of publication. But the request from OSP is still there, probably with his name and documents attached. But it is that for the purpose of Mr. Ofori-Atta's complaint of service, they want to investigate how authentic the application is. And indeed, service does not connote hearing from the public. So if I'm coming here and you have sent me a process and you are talking about it even on your platform, that does not connote service. And indeed, for criminal proceedings of that nature, you must serve the person, not...
That is, that you must serve the person.
That person.
Physically.
The suspect, you must
him.
Serve him. Only to say that if you are not able to serve him personally, there are other means of service, genuine service, substituted service. You go to the courts and find the court's orders, and the court will order you how to effectively serve that person. Circumstances will determine. Again, non-service. When you don't serve a party, a process, you don't start anything. So I'm worried, why will the Interpol place him on red alert when there is so probably evidence of non-service? So I'm also worried.
So that's why, you see, because we talk about the availability of new information, a review process that's ongoing.
Right.
And the reason why,
I want to believe that Interpol was convinced of this primary requirement of service. That is why he was so advertised. If that is not the situation, then I'm worried about that informality. So,
but then again, does it mean, and this is what Kpebu said earlier, does it mean that if, for instance, if he is seen today, he cannot be arrested?
Yes, because from the records and from what the lawyer is saying, he has not been officially notified, means he has not been served. And what the lawyers are also saying is that if he has not been served, then he's not ready for any. And again, he says that he will return once he's officially notified. And I'm saying that the notification must be official. I mean, that is the requirement of the law. But when OSP also says that I saw him leave, I couldn't arrest him. OSP has police powers as per his law. So OSP can arrest. So if OSP, yes, if OSP didn't arrest him, he has to explain why he didn't arrest him. And in any case, if OSP also wanted to formalize the arrest, he could have gone for absconding warrant, which would have been served to the border security agencies for them to even effect the arrest. So complaining of inability to arrest, for me, it doesn't stand with me. He had all the powers and all the opportunities to effect the arrest. It was by his decision not to arrest that he was not arrested. So Ofori-Atta didn't do anything by going through the process and getting out of the country. We cannot charge him. The person who was supposed to have done the thing also, if he decided not to do it, that he has the explanation.
Well, he's explained why. He said he didn't have the cooperation of the other state agencies.
But he himself didn't need any cooperation. He himself, if I'm suspected of having done something that requires my arrest, he himself is vested in enough powers. In fact, most of these laws, when they were crafted, I was part of the discussion. So even the Yoko boss and his deputy, they have powers of arrest under the Police Service Act. Because they have police powers. It is only the Gold Board that the power was limited to interrogation and searching. There was a reason to do that. So Gold Board has no power to arrest because Gold Board has not been vested with the totality of the police mandate. It is limited. If you go to Gold Board, as you see that there is limitation in the powers as given to them. Now, the confiscation of property. In fact, as Martin says, the Act allows for trial in absentia. But it cannot start when you have not done this basic requirement of service. So it is so important because once you have not served him formally, and I want to believe that the lawyers' reliance and insistence on formal service is coming out of their knowledge of not being served formally. And therefore, they are also picking information probably from the media, which I think is also not right on their side. I would not write to OSP upon what I know from the media if my client has...
All right, Abusia teachers, when in some course, our political highway researcher said, former finance minister Ken Ofori-Atta, papa nim ne boni ya wodi nti sisi ene de obeso change na nationality no be US citizen abusia lawyer Martin Kpebu edemu nchimu eba ababedom ya woche se is better se Ghana ye sorry ne ye demonstration enye saade a OSP kisi ejaben obema eye Ken Ofori-Atta afane ho de abusia sama ekoso no na ano ede na medemu besia na madam asesa meje paniwe kuti sama ekoso our political high ni so ha eye POG Media medam ase